My lord, may I be permitted to mention one application for restoration, my lord, which is
When it was dismissed?
dismissed on 19th November. 19th November.
Of
November 2024.
hearing matter?
No, no. Is hearing matter. No,
Hearing
my lord,
or motion?
it was application. It was in application. On 19th, it was in application. And
Dismissed by this bench?
yes, my lord.
My lord, may I be permitted to mention a hearing matter, your lordship?
Hearing matter, please mention after reopening.
My lord, my thought matter, my lord.
Maybe. Only 5 working days are left.
My lord, this is I'm for the petitioner. This is a hearing matter. Affidavits are exchanged, and my petitioner is a very senior person, 80 years of age, and matter is totally this is against the KMC, and totally KMC has very much deprived my petitioner, my client, because that's
Please
why, my
mention
lord,
after
hearing matter
vacation.
exchanged.
After vacation. Please mention after vacation.
My lord, may I permit to mention the matter? This matter is extension of interim order, my lord.
Extension of interim
Yes,
order.
my lord. Hearing matter. The
I
expiry.
have passed the interim order.
No.
So
Justice,
go before the regular bench.
My lord, there is no.
Extension of interim order has to be before the regular bench. Yes.
In presence of the learned,
Lord, there is.
for the Lord, the state, Lord, I am mentioning one matter, Lord, for addition in the list as per my Lord's direction. That is, my Lord Justice Arinda Mukherjee was pleased to pass an order to dispose it of earlier, because this is a case relating to production of answer script in connection with, my Lord, recruitment for the post.
Hearing matter you want inclusion. Please mention after vacation.
My lord, this matter is
Contempt application.
2021.
Contempt hand over the slip.
Your lordship, 2021 matter, my lord.
My lordship,
2021 matter, my lord.
2021
matter.
Yes.
My lord, expire only 25th December will expire. Only pass the order and extend the matter and hear
For the regular bench. Extension of
my
interim order has to be
may I
before the
permit to
regular
mention, my lord, this is a group.
Call the list.
Group 9 matter, your lordship, this is in motion stage. I'm included. Group 9 matter, this is in motion stage.
Was it assigned before this bench?
No, your lordship.
Then
Actually, my Lord, my client is very much senior.
yes, call the list.
That's why I am hearing matter, my Lord.
Item number 1.
My lord, item number 1, I'm appearing for the petitioner, my lord. There is a small typographical error on page number 3 of the order dated 19th November 2024. Last line of the paragraph number 3 of page number 3.
Yes.
The name of the petitioner is recorded as Gopal Chandra Dotto and others, whereas it should be Bhupal Chandra Dotto and others. That is the typographical error, my lord.
Page 3.
Page 3.
Page 3, paragraph 4.
No, my lord. Last line of paragraph 3.
Last line of paragraph
3. It's ending on page 3.
Chandra Dotto
Yes,
and
my
others.
lord. Yes, my lord. It should be written as Bhupal Chandra Dotto.
Bhupal.
Yes.
Ashun. Attention of the court is drawn to the typographical error which has crept in the order dated 19th of November 2024. Full stop. In the last line of paragraph 3 of the said order, it was recorded that the person liable to pay tax is Gopal Chandra Dotto and others. Full stop. Instead of Bhupal Chandra Dotto and others. Full stop. Let such error be rectified. Let this order form part of the order dated 19th of November 2024.
I'm grateful, my lord.
Other portions of the order shall remain unaltered. Yes, next.
Item number 4 and 5. Item number, my lord, on last occasion we prayed for time and your lordship was pleased to grant us time. But we could not find out the, my lord, record of 2009. So your lordship kindly passed the necessary order. Your lordship kindly remember that the
I told you on that occasion, you will not find records more than that what is before this court. Yes, you are for the private respondent.
I'm for the private respondent.
Yes. You have filed a writ petition.
File the writ petition. my writ petition lordship the 5580
So Bhattacharya, you are the private respondent
Yes,
in that?
Yes.
Yes, what is your prayer in the writ petition? You also paid for setting aside that order, 24th July 2009. Is it the same order?
But lordship the WP number 13605 file the affidavit in opposition. There.
Give me a minute, let me, 24th July, yes. 24th July was the communication order. The order is in effect. What is the ground of your challenge?
Illegal construction or same.
What? The order was demolition. Oh, against you, this order also has been passed. How are you, why are you aggrieved against this order?
The total.
An order of demolition has been passed against you also.
Also, my main private respondent, she lived in the premises that.
What is the name of the petitioner?
Petitioner is, my writ petitioner's name is
Estate?
Ram Sevak Choube.
No, 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 এটা তাহলে কি দিলেন? অন্য দিলেন বোধহয়।
580
Oh, 13605 is Mr. Bhattacharya's petition.
ওইটা demolition তো সুকুমারের ছিল।
5580 টা কোনটা?
ও কি চেয়েছিল সেইটা?
এটাই প্রথমটা।
তোমার ক্লায়েন্ট তো রামসেবক চৌধুরী।
Ram Sevak Choube.
সুকুমারের ক্লায়েন্টের নাম
Manoj Kumar
Manoj
Choube and
Choube.
others, অনেক জন আছে।
In your writ petition here, you have filed a opposition admitting that this order has been kept in abeyance.
prayer B page 11.
Oh, they have paid for implementation,
Yes.
not to demolish the illegal construction of such and such. No, not prayer for implementation of any order.
Demolition.
Have you made a representation? Where is that? Illegal construction is the same holding number involved in that.
Yes.
Same holding number.
Same.
Show me from the order.
Page 21.
Holding number lordship 30/27, 31 by
30 by
28.
27. Yes, give me a minute. 30. Where do I find the holding numbers in that order?
30/27, 31 by 28, 32 by 29.
No, where do I find that order? I do not
The-
find it.
My writ petition and SRP file.
No, no, no. Your writ petition I have got in that order, reasoned order.
Page 87.
Page 87. 87. Oh, concerned. Yes, yes. 30 by 27, 31 by 28, 32 by 32 by 20. There is one discrepancy. Kindly come to page 87, Mr. Bhattacharya.
Yes, sir.
The
Yes.
premises number, third premises number you have got at the top,
Yes.
concerned holding.
33 by 30 by plus
29.
4.
No, no, no. Third is 32 by 20.
29 হবে।
But here in the writ petition, it has been made 32 by 29, which is the correct number.
Fact remains, my lord, in her writ petition, the municipal authority used an affidavit in opposition. Your lordship come to pay
But there is no order passed on in their writ petition.
because in view of this, my lord, this honorable court directed this matter should be heard along with that.
All right. So in
But your lordship-
effect, she is trying to implement this
Yes,
order.
yes,
Not in that terms, but
yes, yes.
only one premises number is not telling, which is the correct. Municipality can say.
32 by 29.
32 by 29 or 20? Because in the order, your order says 20.
Yes.
What is the correct number? 20.
29, it should be
29 also.
29. Because the person,
Madam,
All right, so
our client is
they
here.
have to take a fresh decision there.
in any, your lordship kindly peruse page 11 of the opposition filed by the municipality in this writ petition. Page 11.
In her writ petition.
In her writ petition. Page 11, paragraph 8.
Affidavit in opposition. Page 11.
Yes. Paragraph 8.
Paragraph 8, yes.
My lord has got it.
Paragraph 8 I have got.
In this regard, second paragraph.
Yes.
I say that as the earlier order of demolition passing has been stayed by the Honorable Court till date, the same is in force as well as the writ petition being such and such. My writ petition is pending. The minister is not in a position either to give effect or
Where it was stayed?
Right?
Where it was stayed?
In this writ, in my writ,
Your writ petition, the order was stayed.
yes, ma'am. Time to time
By-
extended.
By which order?
Time to time extended, ma'am. Just. Several.
So according to them, since there is an interim order, they cannot implement that order.
Because subject to the final decision of this, your lordship's court in this.
Which order dated? Order dated?
Let me check out. Your lordship will get it from the order sheet itself.
Let the operation of the order placed at state till the third week of long vacation. I think that was extended.
Yes,
thereafter.
time to time extended. My
Order.
last time extended on 17th October. Yes. Last order is 17th October 2022.
All right. আসুন দুটো রিট পিটিশন না একসঙ্গে তৈরি হবে the petitioner in WPA 13605 of 2009 has prayed for setting aside the order of the Mr. Bhattacharya, you have not challenged the order of
Yes,
demolition.
I have challenged. I have taken the ground. I have taken the ground.
No, grounds you have met. Kindly come to your prayer. Which order you have prayed for setting aside?
July 2009, paragraph
24 July 2009 is not the order impugned. Kindly come to page 86. That is the letter.
Just a minute.
Order starts from page 87.
Page 17, my lord, I have annexed it. This starts from page 17. Your lordship,
Page?
17, annexer P17, page 86.
Yes. So that is not the order. That is the forwarding letter, Mr. Bhattacharya.
That is the forwarding letter.
So-
My dear
So
lordship,
you have not challenged the order. You have challenged only the forwarding letter.
your lordship kindly produce this, my lord, communications. What it says, my lord. Your lordship kindly produce.
Even if it is set aside, that cannot be set aside. That order remains.
My lord, there is no such demolition order except this. There is
No, page 80. Next page.
87 is my lord, note sheet.
Yes, that is the decision.
Note sheet, my lord, and that has been communicated by this.
Yes, so
That
that
has
is
been-
the note sheet, but that is in effect the decision.
My your lordship kindly peruse the last paragraph of this covering letter. Now, in view of the above and in compliance with the order passed by this Honorable High Court, Calcutta, you are hereby required to demolish the illegal construction in holding number such and such in Mohalla such and such within 15 days from the date of receipt of this letter. Failure to comply with the above instruction will compel this municipal authority to execute the same at your cost. This is, my lord, in effect, this is the order, not only the communication.
Order dated 27th February 2009.
their enclosure is this. Enclosure is this.
Ashun. The petitioner has prayed for set the petitioner in 136 has prayed for setting aside of the order dated July 24, 2009, passed by the chairman, West Bengal Municipal Act, passed by the chairman, Hugli Chinchula Municipality on July 24, 2009. Full stop. By the said order, the petitioner was directed to demolish the illegal construction in the holding numbers as specifically mentioned in the said order within the time limit as stated therein. Full stop. The petitioner in WPA 5580 of 2016 has prayed for issuance of a writ of mandamus commanding the respondent municipality to demolish the illegal construction of the building comprised in 5 holding numbers in Rajbati Mohalla within ward number 19 of Hugli Chinchura municipality. After hearing the learned advocates for the respective parties, this court finds that after perusing the reliefs claimed in the aforesaid writ petitions, this court finds that the petitioner in WPA 5580 of 2016 is in effect praying for implementation of the order of demolition passed by the municipality, which is under challenge in WPA 13605 of 2009. Paragraph. In view thereof, this court is of the Mr. Bhattacharya, there was the direction that these two matters are to be heard analogously.
It's subject to correction. That was the direction.
There was the direction.
That is why it was tagged.
In view thereof, the aforesaid writ petitions are
8th June 2000.
are heard analogously. Full stop. Paragraph. Mr. Bhattacharya, learned advocate appearing for the petitioner in এখানে না দুটো করে দেবেন যেখানে বলেছি না মিস্টার ভট্টাচার্য পিটিশনার ইন WPA 13605 ব্র্যাকেটে লিখবেন ফর শর্ট WP1 ড্যাশ দিয়ে 1 আর পরেরটাতে যেটা আছে WP-2 ইংলিশ 212 ঠিক আছে হ্যাঁ লিস্টে মানে এমনি 1 2 করে দেবেন তাহলে আর পরে আর পুরো নম্বর বলতে হবে না Mr. Bhattacharya, learned advocate appearing for the petitioner in WP1 submits that a coordinate bench in WPA 5189 of 2008 directed the Board of Councillors of the municipality to take a decision in accordance with section 218 of the West Bengal Municipal Act. He submits that the order passed by the municipality on July 24, 2009 is not in accordance with the provision, is not in accordance with the directions passed by this Honorable Court in the aforesaid writ petition. First up. Paragraph. The learned advocate appearing for the petitioner in WP2 submits that the petitioner in WP1 has made illegal construction in 5 holding numbers, and the municipal authority even after coming to a finding that such construction is an illegal and unauthorized one, are not taking any steps to demolish the same. Paragraph. The learned advocate appearing for the Hooghly Chinchura municipality submits that the municipal authority, after inspection was done.
Lordship, the
Behind my back.
last occasion, Lordship.
After inspection was done,
Yes, inspection was.
the learned advocate for the municipality submits
Hearing
that
done on 13/11.
after holding inspection, it was found that
Hearing was take place in absence of my client. In hearing, my client did not take.
hearing were not heard. And on the date of hearing, notice was served, Mr. Bhattacharya. You did not appear. You chose not to appear.
I submitted a representation that you should not hear because of this matter. The matter is pending before the High Court. That
Oh, prior to that, you have challenged. Inspection, it was found that there was unauthorized construction in the aforesaid holding numbers, and after giving an opportunity of hearing to the respective parties, the order of demolition was passed. He submits that the order of demolition was passed pursuant to the directions passed by this Honorable Court in the earlier writ petition. Full stop. Paragraph. In reply, Mr. Bhattacharya submits that no inspection was carried in the presence of the petitioner. Full stop. Copy of the report of the alleged inspection was also not supplied to the petitioner. Full stop. He further submits that since the petitioner has challenged the order, no, Mr. Bhattacharya, you have challenged the order. When did you approach the High Court? You said since you have approached, you have prayed for an adjournment.
Your Lordship, kindly peruse once the impugned order.
Yes.
Page 8. In obedience with the order, Honorable High Court, Calcutta passed and such, the matter was heard by me on 31st October. Page 86.
86. So according to you, 24th July you are not present.
No, my lord, 31st October 2008, second line.
Yes.
Second line.
Yes.
No such hearing took place according to me.
No,
as
but
you-
you filed the writ petition when?
I have,
After that,
after this.
so why did you not appear?
Madam,
You
then,
chose not to appear, Mr. Vadajaji.
madam, in that I have to,
You chose not to appear. It's
But
not
I-
that you have, since you have filed the writ petition, you could not appear, because writ petition filing was subsequent.
subsequently.
কি বললাম? না না না, ওটা না। Full stop. তারপরটা কেটে দিন, ওই পর্যন্তই থাকবে। হ্যাঁ। Heard the learned advocates for the parties and perused the materials placed. Section 218 of the West Bengal Municipal Act deals with order for demolition or alteration of building in certain cases. Full stop. Section 218 empowers the Board of Councillors to make an order directing any erection, alteration, addition or projection of any building to be of any building which has been executed unlawfully to be demolished or altered after giving the owner of the building a reasonable opportunity of being heard. Full stop. Paragraph. The coordinate bench in WP number 51 WPA number 5189 of 2008 in the case of estate of Sri Raghunath Ji Thakur and another versus the state of West Bengal and others passed a judgment and order on March 27, 2008. By the said order, the writ petition was disposed of by directing by passing the following directions. বলে এইখান থেকে না page 81 থেকে। After going through the said order, this court finds that the coordinate bench directed carrying out investigation and inspection, and the Board of Councillors of the municipality was directed to decide within the time limit specified thereunder as to whether the complaint of the petitioners dated March 1, 2007 merits consideration for registering proceedings under section 218 of the West Bengal Municipal Act. Record reveals that pursuant to the said order, the Chairman of Hooghly Chinsura Municipality heard the matter on 31/10/2008 when Sri Ram Sevak Chobe was present with his lawyer. And
Another date, my lord, on 12th January 2009, second date. 2 dates.
no, page
Page
88.
86.
No,
my lord,
page 88, I am referring to page 88. Page 88, the other date is not there.
I am submitting people from the
I've
communication.
seen that.
Okay,
but,
as you lodge.
কি বললাম? Was present. The chairman in the order dated 27th of February 2009 noted that fresh inspection of the holdings referred to in the said order was done by the technical staff on 18th of August 2008 and 5th of September. 5th of September. What is the date? And on another day. And as per the report of the said inspection, it was found that there are some illegal constructions on those buildings. Mr. The chairman passed an order on 27th of February 2009 holding that all the new construction on the basis of plan passed in the year 2000 is illegal and asked the owners and possessors of the holdings to demolish all new constructions within a specified time, and if they fail to demolish the said construction, then the municipality shall effect demolition. After passing the said order, the chairman placed the papers before the board of councillors for taking a final decision. It appears from the record that the decision of the chairman, Hooghly Chinsula Municipality, dated 27th of February 2009, was considered and approved in the CIC meeting dated 18th of June 2009 and in the Board of Councillors meeting on June 20, 2009. Full stop. It appears from the endorsement made in the said order that the Board of Councillors directed issuance of a demolition order. Thereafter, the chairman, Hooghly Chinsura Municipality, passed an order dated July 24, 2009, directing Manoj Kumar Chobe. You are Manoj Kumar Chobe? Manoj Kumar Chobe to demolish the illegal construction in the holding numbers as mentioned in the order dated July 24, 2009, within the time limit mentioned in the said order. Section 218 of the 1993 Act empowers the under section 218 of the 1993 Act, the Board of Councillors is obliged to give a reasonable opportunity of hearing to the owner of the offending vehicle and
Not vehicle, my lord.
offending building, and thereafter pass an order accordingly. As observed herein before, the chairman of the municipality and not the Board of Councillors fixed a date of hearing and heard the petitioner in WP 2 and passed an order which was subsequently approved. Confirmed, which was subsequently approved in the meeting of the Board of Councillors. The procedure adopted by the municipality is not contemplated under section 218 of the 1993 Act. First up, the coordinate bench in the order dated in the judgment and order dated March 27, 2008 in WPA 5189 of 2008 also directed the Board of Councillors of the municipality to take a decision whether the complaint dated March 1, 2007 merits consideration for registering the proceedings under section 218 of the West Bengal Municipal Act 1993. First up, it appears that the hearing was conducted by the chairman and not by the Board of Councillors, which is contrary to the mandate of section 218 of the 1993 Act. For the reasons as aforesaid, this court holds that there is an infirmity in the decision-making process for which the order impugned is liable to be set aside and quashed. First up, paragraph. Though the chairman in the order dated 27th February 2009 referred to the inspection reports of the technical staff, but it is not evident from the said report as to whether the said reports were, whether the copies of such reports were supplied to the respective parties. First up, Mr. Bhattacharjee would strenuously contend that such reports were not supplied to the petitioners in WP-1. First up, this court therefore directs the municipality to supply copies of the reports as indicated in the order dated 27th February 2009 to the petitioners of the respective petition within 2 weeks
Record is not available.
cannot give
Fresh.
আচ্ছা তাহলে করে দিন না না করা যাবে না কি বললাম মিস্টার ভট্টাচার্য যেখানে strenuously contends না ডিসকোড দেওয়ার is না ওই যেখানে মিস্টার ভট্টাচার্য সাবমিশনটা বললাম strenuously contends that হ্যাঁ না কি বললাম হ্যাঁ না ডিসকোড থেকে কেটে দিন this court was minded to issue a direction upon the municipality to supply the copies of such reports to the respective parties. At this stage, the learned advocate appearing for the municipality submits that the records in connection with the aforesaid demolition proceedings are not traceable. And therefore, the inspection and therefore the municipality cannot supply copies of such reports to the respective parties. First up, paragraph. In view thereof, this court directs the municipality to make a fresh inspection of the holdings in question after serving notices well in advance to the petitioners of the respective writ petitions. First up. Thereafter, the Board of Councillors shall take steps in accordance with the provisions of section 218 of the 1993 Act and to complete the entire exercise and complete the entire exercise as expeditiously as possible, but positively within a period of 8 weeks from the date and 8 weeks after the inspection is made. First up, for all the reasons as aforesaid, the orders dated 24th July 2009, 27th February 2009, the decision of the decision taken in the CIC meeting dated 18th June 2009 and the decision taken in the Board of Councillors, decision taken in the meeting of the Board of Councillors on June 20, 2009 are set aside and quashed.
All points are kept up.
First up, since the order dated 24th of July 2009 and since the aforesaid orders since the orders have been set aside, nothing remains to be decided in WP-2. First up, with the above observations and directions, the writ petitions stand disposed of. There shall be, however, no order as to
No,
cause.
one thing more, my lord.
Urgent
Except
photos.
these two brothers, other three brothers are there, 5 brothers.
Yes.
So notice should be given to all the
All.
brothers. All the
Notice to be,
inhabitants.
যেখানে বলেছি না, shall give notice of inspection to the petitioners in the aforesaid writ petitions, না এটা কি বলেছি? And as well as upon
All
the inhabitants.
all interested parties who are likely to be affected
Yes.
with the result of such inspection.
Man, your lordship has not gone into merits, man. All points are kept open.
It is, however, made clear that the observations made herein before are only to support the ultimate conclusion of ultimate conclusion, and the same shall not prejudice the parties in future proceedings. Yes, next.
Well,
My lord, I appear in this matter for the beloved petitioner WBSCDCL.
Mr. Shoibal Acharya arguing for the respondent number 1, 12 to 16, my lord. He's late before in court number 25.
You are here, madam.
I'm praying for.
Apart
not
from that,
today.
my lord, let me proceed on the last occasion also. He was in difficulty on Friday because his son was likely to leave Calcutta or something like that. My lord, no issue. It will take some time.
It will take some time.
Some time. Let me complete.
Mr. Acharya said he will be relying upon the earlier order. It can be disposed of. For that, I have kept it in under.
I
this
said
heading.
that.
Other-
I said that. That was my submission.
But he is opposing.
He is saying no, it is different because calculation has already been made. Therefore, no further scope for hearing the parties and to, my lord, make the calculation. So, my lord, that point I want to clarify because thing is
All right, let him come. So I'm making it not today.
no, then, my lord, after vacation.
My lord, make it not today, my lord.
Not today.
Today.
After vacation.
He will not be coming for the rest of the days, Mr. Naik.
Let it pass over, short pass over, lordship. Then
What Passover? All right. short
let him come.
Passover.
Let him come.
Yes, short Passover.
Better to get it finished, my lord, today. Otherwise, my lord, lordship.
Yes, call the next matter.
one 21.
My lord, in this matter, I'm for the petitioner.
4, 5, 6.
My lord, I am for the respondent number 4, 5, and 6.
Yes,
My lord, petitioner is a employee, a group employee of a cooperative society.
yes.
He was suspended from the service, then he was terminated. My lord, no charge was framed, no disciplinary proceedings was initiated. Kindly come to the first page 15.
Page
15
of the writ petition.
of the writ petition, my lord.
Yes,
My lord, kindly see the so-called notice first. This is so-called notice as well as suspension also. I'm reading the second para. তার নামে অত্র সমিতির সম্পাদক মহাশয় আদ্য 24/3/2022 তারিখে পরিচালক মণ্ডলীর সভায় বিষয়টি উত্থাপন করিলে এরপর এ সম্পর্কে বিস্তারিত আলোচনা করা হয়। আলোচনা প্রসঙ্গে ইতিপূর্বে আপনার এইরূপ অসৎ ক্রিয়াকলাপের জন্য আপনাকে সাসপেন্ড করা হয়ে গেছিল। তা সত্ত্বেও পুনরায় এইরূপ অসৎ কর্ম কেন করিয়াছেন তাহা আগামী 7 দিনের মধ্যে অত্র সমিতির সম্পাদক মহাশয়ের নিকট লিখিত আকারে জানানোর নির্দেশ দেওয়া হইল। উল্লেখ থাকে যে আগামী 25/3/2022 তারিখ হইতে আপনাকে অফিসে না আসার জন্য নির্দেশ জারি করা হবে। মানে দিস ইজ so cause letter as well as suspension. Now come to the next page. This is the reply of the so cause.
yes, Mr. Vadajaji, how can you terminate without holding any proceedings?
My lord, my first point would be how we can file a writ petition.
Yes.
It is a primary cooperative society without any state control. If somebody is fired from, say, Karnataka Cooperative Karnataka Bank, will he be entitled to file a writ petition for that?
My lord,
This point was raised by state government also, that this writ petition is not maintainable. Then I will come to that.
may I submit, my lord?
Maintainability.
Yes, my lord. There is a breach of statutory violation. Therefore, writ is maintainable. Breach of statutory violation.
Yes.
Kindly see the suspension notice issued by the secretary. According to Rule 56, Sub-Rule 2, only.
Can you maintain a writ for that?
Yes, my lord.
Writ against this. You are challenging an action of an authority who does not fall within the expression state under Article 12.
Yes, my lord. If there is statutory violation, there is urgently.
Are you equipped with the decisions?
Yes, my lord. This Bhavani Adhikari judgment, here is stated there is a statutory violation, then it is maintainable, my lord.
Bhavani Adhikari.
Yes. Yes, which paragraph?
Yes,
Mr. Bhattacharya, decisions are either way. Both sides there are decisions.
In both sides there are this.
even my lord, another judgment I have.
So have you brought the other decisions?
Which is not reported,
Because
but
the order,
is passed by.
one thing I appreciate, but the decisions
Yes,
are on the
one of
either
the
side.
division bench, one of our division bench has
Decisions
passed.
are on either side. You are well aware of those decisions. So, but how have you terminated this? How can you justify your action
Me,
without holding any proceedings? Proceedings are
lord.
required to be.
my lord, if there is a statement, if there is a statement that I have committed this
Admission.
admission,
Yes.
so
Even
in
then,
that case,
admission, maybe you can rely upon that document.
Yes,
But is it the law that if there is an admission, there is no necessity to hold a disciplinary, that may be an evidence in that proceedings. You have to conduct an disciplinary proceedings in that. You can rely upon that you have admitted. But
yes, you know,
is it not necessary to hold a proceeding before termination? What does your rule say?
my lord, even the secretary cannot.
no,
Chairman
it's
cannot.
not that.
My lord, can you see
In that case, my lord, may,
62?
in that case, my lord may give me 2 days time. 2 days time. Tomorrow I can't come, but day after tomorrow I will come.
All right.
No, 2 days time I'm fixing.
For what?
For
You want to
giving,
take some instructions from your client?
not from this, not for instruction, but for Supreme Court judgment that if admission
If there is an admission, there is no necessity to
I-
conduct a proceeding.
I saw one, I will try to find out.
All right.
Affidavit of reply and opposition both are filed only.
The learned advocate appearing for the petitioner submits that without initiating any proceeding, without initiating any disciplinary proceeding, the writ petitioner has been dismissed, from service.
Yes, my lord.
Mr. Bhattacharya, learned senior advocate appearing for the respondent numbers 4, 5, and 6. Press for an accommodation to assist this court on the next occasion. List this matter on day after tomorrow. Kore din. Yes, next.
Great.
Call the next matter.
122.
Ma'am, for the petition, last Friday, she was pleased to fix identical.
But I was
matter,
appearing in the
19.
matter for registrar lordship in this matter, but
Which matter? This matter?
no, earlier matter.
No, 122.
121.
Yes, 121. Oh, your appearance. Acha. You are appearing for whom?
I was for registrar lordship.
Register.
Initially, I
আগের ম্যাটারটা হ্যাঁ উনি হচ্ছেন রেজিস্টার রেজিস্টার ইজ দেখে নিন একটা কত নম্বর
2 and 5.
লার্নের অ্যাডভোকেট
2 and 5 lordship.
appears for the respondent numbers 2 and
2 and 5 lordship.
no Mr. Bhattacharya appears for 4, 5 and 6 kindly এটা চেক করে নেবেন
I was appearing for lordship
for the state করে দিন you are for the state
3. No, 2 and 3.
2 and 3 say so 2 and 3
For
yes
the registrar lordship 2 and 3.
all right yes 122
I'm for the petitioner. Lordship, last Friday, your lordship was pleased to fix the same
Grateful
matter,
lordship.
similar matter on 19th. So let it
on
19th,
19th
lordship. Similar matter.
what is the similarity
Two matters are same, my lord. DPSC, my lord. South 24, and that matter, my lord.
The same panel, same rejection ground, and same.
What is the, do you have the other number?
Yes, my lord. I have 28000. Oh, 20.
List this matter along with bole on 19th.
9. Okay.
Yes, next, call the next matter.
123. So I'm for
Well, this is petitioners.
Yes,
What,
Mr.
my lord?
Lahiri, who is
Yes.
opposing you?
But they are on notice. I've checked
They
up.
are on notice.
Yes. Khaitan and Company and
Who is the learned advocate?
Khaitan and Company and Nilanjan Bhattacharya. Nilanjan Bhattacharya is the Union of India.
Nilanjan Bhattacharya has come to court today. That I've
Yes.
seen.
And Khaitan and Company is the main opposing respondent. They had added themselves as party respondents here.
Yes.
Point is, my lord, I am praying for implementation of the minutes of meeting in respect of the held under the chairmanship of Secretary Ministry of Civil Aviation. Now, the facts are that the petitioners are or were the CPWD employees in
Where is that resolution or the decision?
page 28.
20?
28. I am praying for implementation. May I just put it
Yes, I will
short,
go to that.
or may I just place this? This is self-explanatory.
Yes.
Well, the petitioners were, my lord, the employees of CPWD, Union CPWD. The petitioners were absorbed in the National Airport Authorities. Previously, Airport Authorities of India was National Airport Authorities. This was in sometime 1990s. Now, obviously the airport authorities had to be formed. National Airport Authorities, they were taking all the employees from the different departments of the union, so that they can form a appropriate authority, so that they can function as a PSU. Now, they took in mass transfers in respect of Civil Aviation Department employees who were there under the Department of Civil Aviation under the Union of India, and they also took the petitioners and other similarly circumstanced CPWD employees, so that they can work in the National Airport Authority, which was subsequently formed as Airport Authority of India. As of today, it is Airport Authority of India. Now, my lord, both the permanent employees of the government were absorbed and not absorbed in mass transfer, and thereafter they had retained them.
So you are from CPWD.
I am from CPWD. Another set
You are
was
a permanent employee there.
yes, permanent employee, less than 10 years service.
Yes.
At that relevant point of 1990.
You are transferred.
In mass transfer, and thereafter absorbed in the department, absorbed in the Airport Authority of India, now which is the Airport Authority of India. Now, employees of Civil Aviation Department also were taken into the Airport Authority of India by the same, because they didn't have employees, they had to build up a working force. Now, that is in 1989, we are in 1990. Now, the Civil Aviation Department, the employees of the Civil Aviation Department, they had sought for pensionary benefits under the government. And they had approached the Delhi High Court saying that we should be given pension, because at the relevant point of time when they were absorbed, they were not 10 years in service, so therefore they were not given any option. That is, everything is there. Now, the Delhi High Court, my lord, refused their prayer. My lord, Delhi High Court had only, my lord, directed the authority, that is the Airport Authority of India, to consider their representation. And I think it was refused.
Mr.
No merit, yes.
Thing, service under the civil aviation was a pensionable service.
Yes.
Maybe because of 10 years less, they were not entitled.
Yes.
Whether when you were in CPWD,
yes,
your service was also pensionable.
Yes. Yes, yes. After 10 years, it would.
Yes, yes. That's
yes,
the minimum qualifying period.
Yes.
It was a pensionable
yes,
service.
Yes. Union of India, regular employees, that is admitted. Now,
in some cases, after a period, it's not pensionable, Mr. Lahiri. That is why
no, this is admitted. That they have taken the stand also here. Now, what happened is that
Delhi High Court had simply rejected, saying that no, you cannot claim. And after that, the Department of DOPT, it was remanded back to the chairman of AAI, the Airport Authority of India. By that time, Airport Authority of India had been formed. Airport Authority of India said that no, it is all recorded here that you are not entitled. But the Department of Personnel and DOPT, DOPW, they said that no, they disagreed with the opinion of the chairman of Airport Authority of India, said that no, I'll just place the DOPT wide OM dated 1/7/2013 clarified its stand that it did not agree with the interpretation of AI and stated that all permanent employees who were absorbed in the Airport Authority of India and had opted to retain the pensionary benefits available under the government rules. So there was a difference of opinion. Therefore, this particular meeting was called under the chairmanship of the Secretary Ministry of Civil Aviation, and it was decided, the penultimate part is that all government employees, page 31. I'll just place the entire thing, then I'll come to this, but this is the decision.
Yes.
All government employees, page 31, after detailed deliberation, the following was decided. All government employees absorbed in the
It's not all government employees.
The government employees, sorry.
Yes.
The government employees absorbed in the AAI with less than 10 years of service to be given option for government pension subject to applicable rules. AAI will deposit the employees' contribution of CPF, the Central Provident Fund, in respect of those employees who opt for government pension in the government account. Employers' contribution deposited with the Employees Provident Fund organization for such employees shall be deposited in the government account. AAI to provide all details of such employees to DGCA for fixing of pension. Due diligence be done by DGCA and PAO while fixing the pension and issuing pension payment order. Committee is constituted to review and ensure due diligence is carried out while working out. The committee is that, and thereafter the committee started working, and it was implemented. That will be appearing from page 35 onwards. These are the subsequent letters which was given to the chairman of Airport Authority of India from the Ministry of Civil Aviation. That is page 35 would be that letter, by which.
So this was given effect to.
Yes. I am praying civil aviation. I am praying similar treatment to the employees of the civil aviation department, because we were all similarly circumstanced. We were also, my lord, taken into by the airport. Now, my lord, may I just place the relevant annexures and then come? Kindly comes to page 22. No, untyped tai dekhai da. So that
you make a representation to the Ministry of Civil Aviation.
Made rejected.
Rejected?
Yes.
Where is that rejection order?
That rejection is not civil aviation, is been rejected by the airport authority.
No.
P6 onwards.
Slide only one thing. The decision at page 31, which you are referring to.
Yes.
Was the decision taken by the Civil Aviation Department?
Yes. Everyone had attended. Kindly see.
Yes. But it's the decision taken by the Ministry of Civil Aviation.
Yes, in respect of similarly circumstanced employees of the Airport Authority of India. Airport Authority of India was also represented by its chairman. Kindly comes to page 32. Page 32.
Yes.
Ministry of Civil Aviation.
Yes.
And Airport Authority of India. Everyone was represented.
Yes.
So therefore, now, my lord, may I just now place the minutes? May I just place it?
Show me the rejection order.
Yes, rejection is page 71 onwards, P6 bunch.
So it's the same for all.
Yes, same for all.
So what is, show me one of
page 70, eta koto?
70.
70, yes, 70.
Yes.
Petition number 1. Reference to made a representation such and such, and copy enclosed office benefits under less than 10 years. In this regard, it is stated that your application for grant of government pension has been examined. However, in the absence of any such option for grant, we were not given option. That is the decision that you used to give option. For grant of government exercise by you at the time of absorption in AI, your request cannot be acceded to. we were not entitled to option because we were below 10 years. That circular is also there. Now, my lord, may I?
When did you retire?
Last person has retired about a year ago, I think, but most of the
What was the period of service?
from 1990 onwards.
But page 70, first paragraph regarding
Yes.
grant of government pensionary benefit under less than 10 years.
Under less than 10 years is when we were adopted. Now, may I just place the minutes? It will be evident.
Yes.
Its entirety, because this has to be gone into.
Yes.
Kindly comes to, before that, I'll just place 2-3 pages so that I can show who I am. Kindly comes to page 22. 22, my lordship, is that
Page 22.
Yes.
Yes.
I have a typed copy, but I am not relying upon the typed copy because the typed copy is more erroneous than this one. It is easier to read this.
Yes.
Subject is absorption of CPWD workers belonging to WC estate and regular CH transfer categories in the National Airport Authority. Consequent upon acceptance by the DGN CPWD New Delhi of the technical resignation tendered by the following workers stand relieved from their respective posts in Calcutta Aviation Electric Division CPWD, Calcutta, with effect from 30th June 1990 N for absorption in the National Airport Authority on the standard terms and conditions issued by the Department of Personnel Training and such and such. Now, these are the terms and conditions. The names of the petitioners would be at page 24. I can point out some names. Names and designation of the staff of CPWD in different categories who are absorbed in NAA, National Airport Authority. Lordship would kindly comes to serial number 44, BN Late. He is the
Serial number?
44. In that page itself, here, last.
Serial number 44.
Yes, page 24.
Oh, 24.
Yes.
Yes.
Serial number 44 is petition number 11.
All right.
Thereafter, next page, serial number 106 is petitioner number 1.
All right. So
we were absorbed. This is to show as a sample. Now, kindly comes to page 26. This is the malord forwarding of that malord minutes. This is regarding long pending pension issue of AI employees who have been absorbed from erstwhile Civil Aviation Department to National Airport Authority. This issue was deliberated at various levels for last many years. After examining the issue in details, I am placing from page 26. Lordship is there?
yes,
Yes.
yes.
After examining the issue in details, a meeting was held with the Additional Secretary Pension, Department of Pension Provident Fund, and what is the W? DOPW by such and such, MOCA. There are several short forms have been used, and member such and such. Member HR is member human resources. AI along with the terms on such and such based on the discussion. JSFA has sent a note dated 17th October 2016 indicating various options with a request to carry out detailed exercise by AI. AI also has been asked to provide their comments at an earlier date. JS and FA has also sent a reminder to AI on such and such. However, till date, we have not received any reply for AI. We are also repeatedly getting representations on this issue, including the grievance raised in PG portal. It is also submitted on similar issues of the other departments, was earlier flagged in the Pragati review of the Honorable Prime Minister, and it was reviewed it was viewed very seriously on such occasions, including penal action against the officers concerned. Since pension issue of AAI is a long pending and AAI is not coming out with any concrete reply, we may again request such and such. Now, my lord, this had culminated to the meeting being held. Kindly comes to page 27. This is the forwarding of the meeting. Thereafter, at page 28, which is the meeting minutes itself, may I place from paragraph 4 onwards, page 28.
What is the scheme for pension of this National of Airport Authority of India?
Airport Authority of India, they have said that they have not said, basically they have sent one.
Is there any pension scheme of
Yes.
Airport Authority?
Yes, yes. I think it is, they have been covered.
So you will be entitled to that pension scheme.
Yes, but my humble submission is that I am entitled to a better, my lord, option if this option is
According
given.
to you,
which has been
that
given.
the option government pension is a better option than the pension. So you want that.
That has been given to civil aviation.
After you have taken a conscious decision to
This has been done.
come back
no,
to
no,
this.
that was no option.
So
That was no option. That is the point. We were not given any option because we were less than 10 years. That is the point. They have, in the entire service period, we have not been given option. I understand. If once you have
been
opted,
given option, so could
that
you,
was the
after
grievance.
coming over to a PSU, could you opt for government pension?
That is what has been delivered here, and it has been allowed. List of participants. While welcoming at the outset, the background of the cases was placed before the participants. In accordance with the provisions of National Airport Authority Act 1985, around 7,300 employees of erstwhile Civil Aviation Department engaged in such and such were transferred out en masse on National Airport Authority, which was subsequently, along with International Airport Authority of India, converted into Airport Authority of India. These regular government employees were absorbed in NAA/AAI. At the time of absorption, AAI should have obtained in writing from all such employees their options relating to the pension benefits as per government decision contained in the Department of Pension and Pension Welfare's memo number such and such. This memo is annexed, I'll show. However, as per records available, it is noticed that such option was given only to those employees who had rendered more than 10 years of service as central government employees before joining AAI. Evidence is not available on record to indicate that such opportunity to exercise such option was made available to employees with less than 10 years of service in the government. The officials with less than 10 years of service in the government prior to joining AAI approached High Court for a legal remedy. The stand as taken by the AAI was supported by the High Court, should have been Honorable High Court of Delhi, which in its judgment-wide order dated such and such observed inter alia following. It is well settled that petitioners cannot claim the benefit of both PSUs and the government. Since the petitioners exercise the option of absorption with the terms and conditions of the pay scale of PSU, they cannot now revert back and ask for pensionary benefits under the government. Having opted for absorption by the option given on 15 September 1989 for being absorbed in PSU autonomous body, thus adhering to its rules, the petitioners cannot now fall back and claim the retention of pensionary benefits. In view of the aforesaid decision, I find no merit in the present petitions. Petitioners are dismissed. What your lordship had fallen from your lordship. In WP number such and such, the Honorable High Court of Calcutta, wide order dated 16/9/2013.
That is the entirety. You can come straight away to page 31, paragraph 8. That is the reasoning for extending those benefits.
Paragraph 6 would be at page 30 also to some extent relevant.
Yes, 6, 7 and 8 you can place.
Yes. 6. It was clarified by the Department of Pension and Pensioners Welfare. This is DP and PW. Write their secretary's letter dated 10/8/2017 that denial of option to retain pensionary benefits available to employees with less than 10 years service at the time of absorption under the government rules or to be governed by the rules of PSU on absorption in PSU was not in conformity with the DOPT dated such and such, that is 5/7/1989, and that the pension is required to be paid on the basis of the last drawn pay by the employee on final retirement from PSU and not on any notional pay in the erstwhile scale. JSFA informed that the Director General of Civil Aviation is disbursing pension to AAI employees who had rendered more than 10 years of service and opted
Yes,
for government
so
pension.
Here, Directorate of Civil Aviation,
Yes.
they are disbursing pension. And
Who
these
had rendered
employees-
more than 10.
Yes,
We
yes.
were less.
And
They were
these
also
employees
less.
belong to civil aviation.
Yes, they belong to civil aviation.
aviation
They were given option.
Yes, they belong to civil aviation. They have been transferred from civil aviation to AAI, and
They were given the
civil
option.
aviation was paying pension to AAI.
They were given the option because they were more than 10 years. We were not given the option, and these persons were also not given the option because we were less than 10 years.
Yes, yes, that is one part. The other part is the civil aviation was disbursing pension to AAI employees.
Yes, and she suggested similar methodology to be adopted for.
Yes, who is she?
She is the Director General of Civil Aviation.
Yes. So civil aviation said that similar
Highest.
methodology, since pension is being paid by the civil aviation to AAI, so a similar methodology as for civil aviation employees can be extended to these who were transferred from civil aviation to
AAI.
8 is very relevant.
AAI who
8
had
will be very
opted.
relevant.
Yes,
Next
yes.
place 8.
State that pension should be paid only after recovery. Secretary also sought the information whether based on the combined service in the government and AI, employees of AI are getting higher pensionary benefits compared to similarly placed employees of DGCA. On this, member HRAI clarified that salary drawn by both officials are comparable and no significant difference is found. Secretary has directed
So,
member
This
to
is
give.
one of the criteria. So
No, this
prior
is
to that-
contention of the AI.
Yes, yes, yes. So prior to,
But this was not upheld.
Mr. Lahiri, on these two considerations, this decision was taken. Because prior to that, because these two of civil aviation and AI, this salary structure is comparable. From CPWD to AAI, their salary structure is to be compared.
Let that exercise be done, but
So
point
who
at
will
the
do
end
that
of
exercise?
this, if it
Cannot directly be, court cannot direct this implementation of this order to them, because these are the ingredients which have to be tested.
court can always direct the civil aviation or whoever is the person concerned to consider and see
That
as
is
to
why I
whether
asked
they are
you. So-
similarly circumstanced.
Yes.
If similarly circumstanced, you are,
Yes.
because the wordings are,
Because these are the factors, pay structure and other things, whether they are same, that is to be considered.
but the reason given by AI is totally inhonest, because at that relevant point in time, of course, we were under 10 years, so therefore no option was not obtained. Anyone under 10 years, even civil aviation and my lord, these CPWD employees, other employees, even
That
if
is the representation made by you.
representations are several representations, same.
No, a comprehensive, Mr. Lahiri, all these facts are to be stated in your representation. Once you claim a similar benefit,
Place
you have to
38
show
onwards.
how you are similarly placed. Not
Yes.
merely because,
38 onwards.
not
we have
merely
said.
because both of you were observed in AAI,
Huh.
cannot make both these categories of employees similarly situated.
No. I have prayed so. I have
Because
searched.
these are the distinguishing features.
Yes.
Where is that?
Page 38. That the
38.
yes. Bunch. P5
Only
is
one
the bunch. Yes.
comprehensive.
Page 38 is one bunch.
It's only less than 10 years, no option given. Nothing more than that.
Yes, this is as an employee, my lord,
Like offer
this is
letter
enough.
shows both the type of employees would be getting same benefits, not so after the CPW were deprived of the same pension that are being enjoyed by CAD employees in less than 10. We, the CPW who had served less than in central government should be getting full government.
We have simply
What is the meaning of paragraph 6 of this representation, page 38? What do you mean to say by this?
NAD is national.
Paragraph 5 also, present employees of CAD, what is CAD?
CAD is Civil Aviation Department.
Yes.
Who rendered less than
The CAD who rendered less than in central government are eligible for full, but the employees of who are absorbed in such manner and rendered less than have been deprived from such.
they are enjoying because of this minutes,
This
minutes, and we are being deprived. That is the representation.
And paragraph 6,
That during the absorption process in NAD, all documentary evidence like offer letter shows that both types of employees would be getting same
so
benefits.
you refer to that offer letter.
Yes,
You are
yes.
placed now.
Yes, yes. Now, after many years, we are CPWD employees are deprived of the same
This you
pension.
have made to airport authority.
Yes, airport authority being my employee because they are the pension disbursing authority at the end of the day. My humble submission is that in any case, government employees, the wordings in respect of page 31 is that government employees absorbed in
So now,
AI is
as it appears from this, that minutes,
yes.
the pension will be disbursed, pension to AI employees.
Now methodology
Disbursed by the Director General of Civil Aviation.
No.
Kindly come to
Kindly, my lord,
paragraph 7.
kindly comes to the implementation part. How this has been. That is why I wanted to show page 35. Kindly comes there.
35.
Yes, yes. This is how it is being implemented by the airport authority, by the government of India through the airport authority. May I just place it?
Yes.
Paragraph 2 is as per such and such the minutes. A. How this has to be done, the methodology. To call for stroke obtain the option from all employees of CAD transferred en masse to NAA stroke AI who were not given the option to exercise their option for not given the opportunity to exercise the option for pension, that is employees who have not who had not completed 10 years of service in government at the time of their transfer stroke absorption in AI immediately. Option in respect of those employees who are already retired stroke expire has to be obtained on priority.
Yes, I have seen this. No, kindly come to page 31, paragraph 7.
Yes. This is JS and FA is Joint Secretary Financial Advisor.
Yes, yes.
Yes.
Informed that Director General is disbursing pension to AI employees who had rendered more than 10 years of service and opted for government pension.
Yes.
So in their case,
the different class.
No. This she suggested
yes
similar methodology be adopted for the employees, for the remaining employees.
Yes.
So remaining
that is
employees,
option. Give them an option, and thereafter, if they
Yes.
want, you do this.
Yes.
Transfer of funds
that
and
the
all.
pension should be paid only after so Director General of Civil Aviation is releasing for those who have been transferred.
Yes.
So, but in your case, they will not give.
Because we were not given the option. She said that persons who
Mr.
had
Laidi, if you have given an opportunity to exercise your option,
yes,
who will pay the pension?
the entire fund. Kindly. That is why I wanted to show page 35. May I just go through and thereafter tell your lordship? F would be, may I just place it? This is very important.
Yes.
Page 35. Option in respect of such and such B I have placed. AI shall provide the relevant details of such retired employees, expired employees who are such and such.
It is
Such and
here
such.
to make regular
Yes,
payment
yes,
of
yes, yes.
pension.
That is what I'm.
But now,
F.
yes, I've seen that.
Yes.
This tallies with paragraph 7 at page 30.
Yes.
So now, whether this DGCA will take the responsibility of your client cannot, or will not.
They
Here
have
lies the
taken,
difficulty.
they have taken the responsibility of
It is
similarly
your
circumstanced.
parent company, because the parent company of those was DGCA. DGCA is taking the responsibility, I will pay pension. Your parent company, if it takes, airport authority is not paying pension.
CPWD, CPWD.
So CPWD.
CPWD wing of Union of
Yes.
India. There cannot be
So-
two stands by two departments.
So that is the thing. So have you implemented CPWD?
Yes.
Who is representing him?
Union of India.
Of India, my lord, learned senior counsel, Mr. Nilanjan Bhattacharya is appeared.
Where is he?
See, he just left the court, my lord, for the personal reason.
He was present in court. We have
Yes,
seen him.
yes,
He
sir.
moved the matter.
He was present, my lord, just few minutes back, my lord, he just left the court, my lord.
How many minutes back?
Few minutes, just few.
Few minutes
Few
back.
minutes, my-
Prior to that, this matter was taken up.
Few minutes, my lord, prior to the taken up this.
Taking
matter.
off this matter. Few minutes prior to taking off this matter.
Kindly keep the matter in the.
The entire
in-
time is
in the
wasted now.
Witness
My
day, my lord.
lordship remembers, kindly keeps it at tomorrow. Once,
Tomorrow is a difficulty, my lord. He is before the Honorable Supreme Court, my lord.
day after
tomorrow is
tomorrow,
the-
I am there before the Honorable Supreme Court. Day after tomorrow, I am there before the Honorable Supreme Court. SSC matters.
So both of you fight there.
Fight there. Yes.
So
Lordship
it
may,
appear then after the vacation,
then my lord part hard. Then part hard.
part hard.
Well, extensively.
No.
Ex-
Part hard is both the parties are hard.
Both the parties. Yeah, part hard means one of the parties have been hard. Partly hard, one party.
Mr. Lahiri, I do not, I am
Then Friday.
not making any of the
Then
matters.
Friday. Thursday, I think. Then Friday. Kindly keeps it Friday.
Ashwin.
Because I will be, let us hope,
But he is for the Union of India.
Union of India.
Who is for airport authority?
Lordship, I am appearing for
Company, I think
on
someone
numbers
is
4 to
appearing
8.
virtually.
Yes, madam, you are appearing for airport authority.
Lordship, yes.
Yes.
Lordship, the concerned advocate is not available today. We filed.
Yes, madam, why are you discriminating between two sets of employees?
Lordship, the concerned advocate is not available today. Can the matter be
Concerned advocate. Who is the concerned advocate?
the advocate on record, Mr. Pratik Shanu? He is not available. The advocate on record, Mr. Pratik Shanu, he is not available. We filed our affidavit
Will
to
argue or any other counsel will argue?
very well, Lordship.
No, I'm asking, not very well. I'm asking whether the advocate on record will argue or any other counsel will argue.
Lordship, I have to take instructions on this. Lordship will kindly keep the matter on Friday as
Heard Mr. Lahiri Lanet, senior advocate for the petitioner. An accommodation has been sought for on the ground of the learned advocates representing the Union of India and the Airport Authority of India, respectively, as jointly paid by the learned advocates for the parties. List this matter Friday. Korodin. Yes, next.
grateful.
Would your lordship kindly take seat of the Passover matter? Well, very
Let me,
short.
let me
Very
call. Yes, I will come back. Yes. Next matter. Dakun.
124.
Lordship, I am for the petitioner in item 124 being led by Mr. Shayan Sinha. The affidavit in opposition in this instant matter was served on 13th December. So I am praying before your lordship some time to file the affidavit in reply.
Affidavit.
I'm
the
appearing on behalf of the
advocate
state.
for the petitioner. Praise for
I'm filing the affidavit in opposition, Will.
the affidavit in opposition filed in court today by the respondent numbers 3, 4, and 5 is taken on record. Who is for the state? Mr. Shain, HON'BLE Shain.
Lordship, I am appearing on behalf of the state respondent. Lordship.
Yes, madam, have you filed your affidavit?
Yes, Lordship. Lordship kindly keeps it after vacation. By that time, we file that.
The learned advocate appearing for the petitioner prays for extension of time to file the affidavit in reply. So yes, how much time you want?
1 week after vacation, your lordship.
As prayed for by the learned advocate for the petitioner, let affidavit in reply be filed within a week after reopening of this court after Christmas vacation. List this matter 2 weeks after the opening of the court after Christmas
Much
vacation.
obliged, Will.
So grateful to you. Lord.
Yes, next.
Grateful, Lordship.
125.
Appear on behalf of the petition.
Yes, Mr. Balaji.
Millard, this is the matter where my client Millard married one lady on 9th of September 2013 before joining service. Then Millard, the first
Before
wife,
joining service,
before joining service,
your client married,
married a lady before joining the service.
he is not the private respondent.
No.
All right.
Then Millard, the first wife left the house leaving behind minor
What is the
children.
dispute?
The dispute is that a particular Millard order has been issued. This order shows that having regard to the provisions of Millard Rule 15 of the CRPF rules, Millard, I am showing to my lords Millard Rule 15.
So what is the order you are challenging? Show me that.
Millard, I am challenging the last order. But Millard, your lordship may kindly, Millard, I appeal to my lords, lordship may kindly consider this.
Yes, I will come to that. Show me the order. What is
the order, Millard, which I have challenged.
Yes.
That order, your lordship will be pleased to find. That is in the last annexure. That is Millard 27M.
27M.
27M. This is how this has been marked.
Yes.
Now, Millard,
Punishment.
there was, Millard, a punishment. The reason for punishment
What is the punishment?
The punishment is, Millard, I was terminated from service on the ground.
Terminated?
Yes, on the ground that I had married another wife. This is the only particular.
Oh, during the
Yes,
subsistence of the earlier marriage.
Yes. Now, Millard,
Is it a ground for disciplinary proceeding?
Millard, I tell you, lordships, I have checked out the matter. I come to my lords. I have three grounds.
Yes.
Now, Millard, first of all, Millard, your lordship may kindly consider this particular Rule 15. Millard, a very short rule, Rule 15.
Do you have another copy of that rule?
I am your lordship. Plurality of the marriages.
So according to you, if you have married earlier than joining, so this Rule 59 cannot apply.
No, I say, Millard, strictly speaking, if I say so, Millard, I was wondering only one thing. That, Millard, that is the thing, Millard, which my lord has to decide. Millard, in terms of Millard section, Millard 255, a Mohammedan may have as many as 4 wives at the same time.
That is there.
That is
has
there.
been provided. But
That
then you
is
have
in
to
the respect of
Mr.
the.
Bhattaji, there are two things.
Yes.
If you say, in view of that,
yes,
this could not have been incorporated, then you have to challenge Rule 15.
That
you have
yes.
not done.
Yes.
That you have not done.
Yes.
So the other is, you started your submission by saying, if I correctly, or if I have correctly heard you,
yes,
that the petitioner married another lady before joining the service.
No, another lady not. I married, my first marriage was before joining the particular service.
Yes.
The second marriage was after joining the service.
Then you are hit by Rule 15.
Then Millard, your lordship may kindly consider second wife got divorced on 4th of March 2024. 4th of March 2024.
4th of March 2024.
2024. The second lady whom
divorce is another thing.
Yes.
Marriage is the offense.
Yes, marriage is the offense.
Or is a misconduct as per this. Not an offense, it's a misconduct as per
Now, Millard, I tell you.
So whether it's divorce or other thing, that does not say.
Now, Millard, your lordship may kindly consider one aspect of the matter. Millard, I find, Millard, so far as the rule, Millard, which I have handed over to my lords, that, Millard, it does not take into consideration so far as rule, the section 255 of the Mohammedan law is concerned, because this is the personal law. This personal law, Millard, kindly see this personal law.
No. It says notwithstanding.
Yes.
So it overrides that. Notwithstanding, Rule 15, do you have a copy of that? Is why I asked you. Do you have another copy of this? You have got no.
I've asked.
Yes, Mr. Bhattacharya, kindly sees. It has a non-obstante clause.
Just a second, Milord, I- Yes, notwithstanding that such subsequent marriage is permissible under the personal law
Yes.
for the same.
That is
for
what
the-
you are trying to urge.
the-
So,
the-
non-obstante, notwithstanding anything that
Yes.
your personal law allows you,
Yeah, it allows
allows
me.
plural marriages,
Yes.
even then this will be, you have to take permission.
Now,
If you have not taken permission,
Yes.
it does not say, Mr. Bhattacharya, that it's barred or anything.
yes.
If you take permission, permission can be granted. The misconduct is marrying without
Plurality
obtaining
of the
permission.
marriage. The misconduct is plurality of the marriage.
Yes, without taking permission.
Permission. Yes, yes.
So if you
Now-
have not taken
Now,
permission,
Milord, kindly
Mr.
consider.
Bhattacharya, what is there in this matter?
Now,
Nothing.
Milord, your lordship may kindly consider the order which they have passed.
Yes.
Now, Milord, it appears, Milord,
Yes.
that page 27M,
Yes.
that fourth
This is
number,
the charge. No, this is the order.
yes.
But that is the appellate authority's order. The original disciplinary authority's order
Yes.
is that page 20.
Yes.
Appellate authority has affirmed the order.
Yes,
affirm
yes,
the order.
yes.
Yes.
Now you,
27A, which portion?
now I am showing to my lords, Milord, this starts, now the operative portion. Now, paragraph 6.
Paragraph
6. One thing which I should submit to my lords, that this particular order was passed, it was passed in November 2023.
This order was passed on.
November 2023, subject to correction of my learned friend.
Where do I get that order, Mr. Bhattacharya?
Milord, that my lords will be pleased to
Yes,
find.
his date, some blank day of November 2023.
November 23. This is all. This is what I can also get.
Yes.
Now, Milord, the paragraph 6 says that the appellant has not presented any new facts or concrete evidence or documents in his appeal which could exonerate him, or on the basis of which the commanded 256 battalion number such and such can be interfered with by the appellate authority on the sentence passed. Now, my lord, I can only pray before my lords.
You will be allowed to make a representation before
Yes,
the
sir.
appellate
Yes, sir.
authority
And
stating that
I
this-
have
you are
that,
the second,
that
there is a
the
divorce
second wife
between you
got
and
divorced
second-
on 4th
second
March.
wife.
Yes. Otherwise, I say, Milord, that I have nothing more to say. But again, at the risk of repetition, while I was preparing myself, I found, my Milord, there is a principle which is known as casus omissus.
There is no casus omissus here.
Milord,
Because here, Mr. Bhattacharya, consciously Rule 15 was
no,
incorporated.
I say, Milord,
Conscious of that the personal law permits multiple marriages.
when personal law is subsisting and a particular law is incorporated, that you cannot marry twice. This is the plurality of the marriage
Twice,
is not
thrice,
permissible.
whatever it might be. Yes.
Then, Milord, your lordship may kindly consider that as to whether, Milord, the concept of casus omissus can be invoked, and I found that the Supreme Court, Milord, in a case.
No, how do you say it's casus omissus? Because
Why? Because, Milord, they have not
notwithstanding that
they have not incorporated that if you have more than one wife, you should inform the authority.
Yes, that is there. Permission taken. Permission taken.
Without first obtaining the permission
Yes.
of the government.
Yes, permission is there. There is no casus omissus.
Then, Milord, my only remedy is to make a day, because otherwise the man, Milord, will be suffering. What is his age? His age is on instructions I submit is 30 years.
What do you say? It's prayer for consideration of the representation if he makes a
Whether it can be done. I am fortified by judgment. I will place it, my lord. I think I am fortified by the judgment of the apex court. I will place it, my lord.
On what point? On what?
This point itself, my lord, whether the representation can be made. That is not the question. Question is
No, whether the representation can be made.
my lord, he is claiming it under the equity. Because
He is claiming?
under the equity. Equitable because he is his age is very.
No, that is for you to consider. The court will not consider that. According to him, the second wife has divorced him. So that is
after all the orders has been passed.
after all the orders have been passed.
Yes, my lord. My lord kindly comes to that. The
my-
disciplinary authority, he divorced it.
The
in
second
year
wife.
after
Bhattacharya,
all
I
the
was
orders
under
have
the
been passed.
impression that during the pendency of the
No,
proceedings.
kindly see this particular why they have considered it, and my lord, in the particular order of the appellate authority at page 270.
No, is it a mutual consent divorce, Mr.
My lord, I find, my lord, kindly see paragraph 8, 270 to 27Q.
Mr. Bhattacharya,
Yes, my
this
lord.
document was only to get away with this order.
This document?
My lord.
Is only with a view to get away with this order of punishment.
After some
No, I
fertile brain advised it and that come up.
I submit
Some
to
fertile brain advised.
I
It is
su-
not even
I submit to my lords, my lord, that kindly take I kindly take, my lord, some equitable consideration. Why I submit? Why?
Mr.
Why?
Bhattacharya,
Because the personal law permits. But what was my offense? I did not take the permission. That was my only offense. And why not? Because I had no legal nicety. I has no knowledge of the legal niceties.
Lord.
I has no knowledge of the legal niceties that this has to be done, this has not to be done. And significant feature is excellent. Page 27Q, kindly see. They are saying, they themselves are saying after November 23, 27Q.
no, what are the modes of punishment, major punishment? What are the heads of punishment?
Removal from service.
No. That has been inflicted. What are the categories of major punishment?
The punishments that, my lord, I have to
In
show
the schedule.
my lord, from my
Yes.
book.
Dismissal, removal, reduction.
That I have
Is
to
it
show.
not shockingly disproportionate to the charges proof?
My lord, no.
For that, you will be.
Then I will come up with the judgment, my lord. In a discipline force, removal of punishment is not a major punishment. It is a minor punishment. In a
minor
discipline
punishment?
force- Yes, my lord. I will come up with the judgment.
Removal?
Yes, because they have the right to impose death penalty. So it has been imposed. I'll come up with
No.
the
Show me from the schedule of these punishments. That is the minor punishment.
My lord, I'll come. The minor and major punishments.
Section 20.
Right. Minor and major punishments. Sentence. Punishments. My lord,
And they
it is-
say
it is
that if the appellant so desires, he can submit a review petition against this order to the inspector.
So have you done that?
My lord, he is
the
this.
statutory authority being given after the appellate authority rejects it. That has not been done. I have stated in my lord.
My lord, that's
There
the
is a
thing.
period. There is a prescribed time limit.
My lord, a specified time limit that I must not make a
Yes,
comment.
review is there is
My lord,
specified.
I have to
So if
see.
he prefers the review, you consider that.
My lord, the
Otherwise, my
punishment
lord,
is, 48, my lord, section 48. It will talk to them.
Section?
Section
আমার
48
check
of the no, that is CISF is
আমি
my lord,
Section 48.
my lord, no, that is BSF. That will, my lord, I'm coming. CISF, no.
No, all right. Prior to that, so you have given him a liberty to prefer a review.
Yes,
If he
yes.
files a review, consider that.
My lord, he choose not to file it within time,
Oh.
then my lord, as your lord, my lord, but it will be a multiplicity of proceedings because my lord, the
Consider
question
that.
asks, my lord,
Consider that and
my
decide
lord,
that.
one judgment I would refer to. He is claiming the right under the equity, that he is of an younger age, he has to support his family.
No, I am not giving him any additional right. You have offered him that he can file a review. I am relegating him to that.
I consider this, my lord, and then, my lord, only paragraph 29 of this judgment, my lord, when there is a conflict between law and equity, which will prevail. My lord knows very well, better than me, that when there is a conflict between law and
No,
equity,
yes,
the
yes.
equity has, the law has to prevail. And the law
Law
is
has
very
to
specific.
prevail. Law, there is a provision, there is a statutory provision for review.
My lord, there is, but he choose not to. We have stated.
So I'm only extending the time to prefer a review. Is there any specified time limit for preparing a review?
Time limit is
What
30
is that?
days, but still
that-
the Lord can extend it.
Yes.
That, yes, your
So I'm
lordship
only
said that
directly, I'm not making any.
by the discretionary power.
That rule 29.
Review is rule 29.
29, the review is Central Industry CIFS. 29 is the provision for review of the CRPF rules.
Rule 28 is appeal. 29 is
29 is
revision.
review. Yes.
Where is
Who rejects
review?
by the competent prefer a petition of revision for the next.
So revision, but I find that in the order, you have said review. Is there any review?
Revision.
But
the after that appeal is rejected, my lord, it is a revision under section 29, rule 29.
No, kindly come to 27Q.
27Q.
Review petition, it has been said.
It must be wrongly typed, but it is revision.
27Q,
Rule
they say review.
29. Rule 29 is revision.
Revision.
All right. So
Yes, revision.
the petitioner has challenged the
Order of termination.
order of the Deputy Inspector General, range CRPF, Ajmer, dated November 2023 in this writ petition. Full stop. The where is the order of the disciplinary authority, Mr. Bhattacharya?
Mr.
Disciplinary authority.
That is, my lord, at page, my lord, 27A.
27A.
The original orders are in Hindi.
These are all in Hindi from page 70. Correct.
Yes, and
Correct.
that is the interpretation that
Yes,
the translation is at 27.
Yes.
The petitioner, while he was a member of the force, was served with a memorandum of charge. Where is the memorandum of charge?
This also has gone down into that. Hindi.
Memorandum of charge.
ঠিকই বলছি তো হিন্দি।
Full stop. The charge leveled against the petitioner was that he has committed disobedience of orders / neglect of duty / laxity in the discharge of duty / other misconduct and misbehavior in his capacity as a member of the force under section 11 within bracket 1 of the Central Reserve Force Act 1949 in the discharge of general duty in which he has married secondly to Srimati Shakila Khatun on 8th of April 2022 while his first wife Srimati Beauty Khatun was alive. Full stop. The disciplinary authority, after considering the materials on record, passed an order removing the petitioner from the service with effect from the date of issuance of office order, that is 22nd of February 2023 within bracket PM. And the said and the petitioner said, and the petitioner was also removed from the force of the said battalion. The Order of the disciplinary authority is dated 22nd of February 2023. Petitioner challenged the said order by preferring an appeal under Rule 28 of the Central Reserve Police Force Rules 1955, bracketed for short the 1955 rules, and the appellate authority by an order dated November 2023 dismissed the appeal petition. However, in the concluding portion of the said order, it was observed by the appellate authority that if the petitioner so desires, he can submit a petition in accordance with Rule 29 of the 1955 rules against the order of the appellate authority. After some argument, Mr. Bhattacharjee, learned senior advocate appearing for the petitioner, submits that the petitioner may be given liberty to approach the authority as per the liberty granted by the appellate authority. Approach the authority in accordance with Rule 29 of the 1955 rules as per the liberty granted by the appellate authority by extending the time limit stipulated therefore.
I may also be permitted to produce the the divorce.
Whatever you want, you file that. I'm not making anything. Otherwise, then I have to make.
No.
The learned advocate appearing for the Union of India submits that the petitioner had an opportunity to prefer a revision petition under Rule 29, but having chosen not to approach the said forum within the time limit stipulated therefore, the petitioner is not entitled to any relief in this writ petition. However, considering the fact that the appellate authority granted liberty to the petitioner to approach to file an petition in accordance with Rule 29 of the 1955 rules, this court is inclined to extend the time limit for approach for making such a petition. The petitioner will be at liberty to file a petition in accordance with Rule 29 of the 1955 rules against the order of the appellate authority dated November 2023 within a period of 30 days from the receipt of a server copy of this order. If
Without a specific time. Server copy. Milord,
server copy, I've said.
Milord, then ultimate time be given. Milord will be, this order of Milords will be uploading within 1 or 2 days. So Milord, a specific time frame, as your lordship please.
30 days from the receipt of a server copy. You can also communicate to that authority.
If a time limit, Milord kindly extend
No,
it up
30 days I have said. Now, what time limit you want? For what?
Milord, today is to 20, today is 16.
All right.
Milord,
So you want
it was to be done by 15th of January or 16th
all right.
of January, whatever.
কি বললাম? Within a period of 30 days না করে with on or before January 15 টা কি হচ্ছে, কি বারটার হচ্ছে দেখুন একবার। না January 15
There will be
it's
an
Wednesday.
There will be an ensuing
Wednesday to.
Xmas vacation. There will be an ensuing Xmas
CISF
vacation.
does not have any vacation. It has only 1 days of 25th.
January 15 2025 কি বললাম?
It is the order that we ordered on or before January.
First off, if the review petition, if the petition under section under Rule 29 of the 1955 rule is filed on or within the time limit stipulated there herein before, comma, the concerned authority shall consider and dispose of the same in accordance with law. I do not know whether any opportunity of hearing is provided. If so, I have read in accordance with law.
No opportunity, if not, may not.
That is why I have not
That is also
expanded
the
the
judgment
scope.
In any quasi judicial hearing.
But Mr. Bhagat, if the rules do not provide for that,
Yes.
if you have, there will be at liberty. So I have said in accordance with law.
Lord, we have filed our affidavit in opposition.
এটা দিয়ে দিন। Affidavit in opposition filed in court today is taken on record. Have you filed any reply? No.
Yes.
Affidavit in opposition and the reply.
Reply টা file করে দাও।
File your reply.
File করেছি।
Just call the next matter.
করেছে না করেছে
126
করে দিয়েছে, এটা করে দে।
The 126 I am for the petitioner. Very short matter, my lord, in terms of the larger bench decision in Abhijit Vaidya's case, petitioner has refunded the amount, PPO has been issued, he is getting pension.
Yes.
But pension has been sanctioned from the date of refund. But Abhijit Vaidya's case judgment has been modified by the larger bench. No, not from the date of refund, from the date of following that his retirement. This is the, my lord, the larger bench modified that. My lord, I have the copy, my lord, the others coordinate base, my lord, pass this order, my lord,
who is appearing for the state?
My lord, before mentioning, I mean,
who is appearing?
Notice was given, Mr. Niloy Banerjee and Jahangir Badshah.
Niloy or Noel Banerjee?
Niloy Banerjee.
Niloy or Noel?
Nole Banerjee. Nole Banerjee.
Not Nole. Noel Banerjee. You are saying Nole.
Naam eta?
Just like Nole appears.
No.
Bal Library Club.
I have given notice before mentioning, after mentioning, also my lord, the matter is running.
They are busy advocates.
And my lord, his junior also, my lord, the Jahangir Badshah also.
Can you call him? Pass over. Yes, call the next matter.
My learned senior friend can appear, my lord.
127.
Who can appear?
Mr. Acharya.
You are appearing for the state.
I am in the panel, group A.
Yeah, so, but he has to take instructions. If you can bring them, or I can engage Mr. Acharya. Try if you can.
Subsequent rectification of the order, it clearly says, my lord, that.
But why it was affidavits were directed in this matter? Why affidavits were directed?
Initially, that was.
You are there.
I am there.
So why are you saying like this?
His lordship was.
He invited that direction.
His lordship was of the view that you exercise option later, my lord, after expiry of the period.
So there is a.
But this honorable court, my lord, allowed the petitioner to exercise option and to refund the amount up to the date of interest. Up to the date of 12% interest for conversion. My lord, as per order of this honorable court, his pension has been sanctioned. Not the suo motu, my lord, as per order of this honorable
You are appearing.
No, he's appearing next matter.
Next matter.
It 126.
All right, pass over. Next.
127.
127 also same.
No. This is, my lord, the widow has come before your lordship. এটা দিন
আমাকে একটা কপি দাও
এটা একটু দিয়ে দিচ্ছি এটা ওইখান থেকে দেখো মানে the widow could not exercise option because her husband died prior to the larger bench decision. my lord has, my lord, the in circuit bench, my lord, the
Jalpaiguri.
Jalpaiguri. Same, my lord, the your lordship knows also contempt proceeding is pending before your lordship. Everything are same. I have also, my lord, the corrected 2 or 3 word, my lord, the just কি দিয়েছিল আসলে নিজে পাস করেছি দেখি কি দিয়েছিল দেখি এই দিয়েছে রিফান্ড করতে হবে আপ টু দ্য ডেট অফ ইন্টারেস্ট আপ টু দ্য ডেট
কি হোল্ড করেছিল যেটা অপশন এক্সারসাইজ করতে পারছে না মারা যাওয়ার সময়
তারা এই যে রিজিশন নিয়েছে 620 তারা দিতে হবে আপ টু ডেট ইন্টারেস্ট 12%। এই জলসা
But in this case, it was died in harness in this matter.
This is, my lord, the retired.
Anita Roy, it was a case of died in harness.
Died in harness. I have given Anita Roy.
In this case, yes, Anita Roy was a case of died in harness.
No. Retired.
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 But,
First paragraph.
Yes. Oh, in the case of Abdul Goni.
Abdul Goni.
That was the case of died in harness.
Died in harness.
Yes, Mr. Chatterjee, what do you say?
Well, when lordship has already hold this up, my lordship, my lord, only
Go through this.
Only, my lord, only, yes, my lord, I have to go through. But only one submission, my lord. Subject to kind sanction. But one person should exercise the option. This is the principle followed.
Yes.
My lord, some cases, some persons may diet or they could not exercise the power because prior to that, my lord, this option exercise has already been over. My lord, my submission would be before your lordship.
Yes.
If the person is up to date is given, if the widow is given his portion committed to the authority, so that lordship has hold that she is entitled to get, as because there is no option has been exercised by the husband because he died. My lord, subject to kind sanction. If that be so, then my lord, my lord, I got the one instruction, my lord. That is the reason, my lord, I want to place before your lordship.
Actually, my lord, widow will not be benefited because
You have not filed any affidavit in opposition. It was the direction to file affidavit in opposition.
Well, I got the letter. This instruction, I got the letter. So I
all right, come tomorrow. Consider this judgment.
Give me 1 day time, my lord. 1 day, yes.
It has been settled now. Division bench also.
Let him go through this judgment. Mr. Jana, learned advocate, appears for the petitioner. Mr. Chatterjee, learned advocate, appears for the state and seeks an accommodation. Stop. List this matter tomorrow. Under the same heading. Yes, next.
Tomorrow.
128.
Just 128.
128.
Petitioner, yes. Have you served?
Yes, my lord.
Yes, what is this matter? Who is appearing for the respondent?
This is a restoration application.
What is the main matter?
This is a tender matter.
Tender matter. What is left now?
No, I'll come.
The tender of 2014.
Yes, my lord. First, my lord, in the first round of litigation, my lord, page 44.
What are you challenging in this matter?
But I had worked for the period of 2010 to 2014. I have completed the work. I have submitted my bill.
Yes.
They did not release it. Now, at that point of time, I approached this honorable court at page 44, wherein, my lord, this honorable court was pleased enough to direct them to give me an opportunity of hearing.
Where is the order of 16th of January 2014, which you have paid for setting aside?
Yes, my lord.
Where is that?
My lord, page 47. Page 48 is the continuation part. Here, my lord, they say that the point of that the amount could not be released just because the subsequent 2 tenders was not completed on time. But 3 occasions, this honorable court directed them to file their affidavits, but they could not file. Ultimately, this matter was dismissed for default in the year 2022. No, dismiss for default na. Baकी order gulo होता है. But if your lordship kindly comes to page 51, here, my lord, paragraph 5. May I read, my lord? From a careful perusal of the files and documents relating to the matter of MS Ghosh Enterprise, and the following facts became apparent. MS Ghosh Enterprise was issued 4 works under the following 4 orders. Work number such and such, date such and such, for executing work of block repairs of outside and inside B type 11 or at Jhanjra.
What is the infirmity in this order?
Malad, may I say?
What is wrong in this order?
Malad, paragraph 5A, I completed it.
Maybe that cannot be decided by the writ court. Whether you have completed, not completed.
Yes,
that
they
is
themselves
a
had made.
question of fact. Now, according, you have made a claim.
Yes, but
according to them, ECL says they have a counter claim, and they have passed this order that they are entitled to this much of amount. So
yes,
some
but
money
that is subsequent. But so far as first part is concerned, so far as the amount of rupees 4 lakh
how can the writ court
96,000.
enter into this, decide all
3
this,
occasions were given to file their affidavit. They chose not to file.
For that, this reasoned order is to be set aside.
No, but at least
At a ground, you have challenged the reasoned order.
yes,
You
but
have
I've
to show
challenged.
from the reasoned order why that is wrong.
Because, my lord, the first part, the claim that I'm making of 496, that I've completed, they have agreed. They say that subsequent 3 tenders that was supposed to be, I did not make any claim on that. For the subsequent 3 tenders, I did not make any claim.
So according to you,
The first
you are
part,
claiming the amount
my
on
lord,
account of tender A.
yes, my lord.
Subsequent tenders you have not completed. They are adjusting their claim as against your claim in tender A.
Yes, but that is not subject matter of contract.
So yes. Show me those contracts. They have a right. They can withhold. Eastern
Yes.
Coalfields.
Eastern Coalfields can, but
Yes. Show me those tender documents.
But after
agreements.
4 years. After 4 years.
They have a right of retention.
But they
have
did not.
dealt with in the division bench of Eastern Coalfield. They have upheld their right of retention.
So far as 490.
Now retention up to what date? Now the subsequent tenders, they can adjust. They have a right to adjust.
But my lord, an opportunity of hearing should have been given to me. They come up and say that these are the things, and more particularly, my lord, they also admitted.
Where is your tender document which says contains this clause of this payment? They have a right of retention.
My lord, page 31.
The question arose as to up to which date they can exercise their right of retention.
But honestly, my lord, I have not come.
Because there was clause which says there was some confusion, no time limit was fixed. So we have interpreted that till which date they can exercise their right of option. Where is Mr. Devnath Ghosh? He is appearing in this matter. No. He usually appears for Eastern Coalfields.
But Ms. Sanchita Roy Varman was appearing.
Yes.
But page 15, my lord, I have stated that there was no
Ghosh
such clause.
appeared in that matter.
My lord.
And Mr. Subhobroto Dotto appeared for the writ petitioners.
But in
just
paragraph
before
14,
the puja vacation, we have delivered that judgment.
But I shall look into it, my lord. Keeps it after vacation, that I shall. In the meantime, I shall serve notice again on the ECL, my lord.
Come, I will decide the restoration also on that date.
My lord.
None appears for the respondents. The petitioner is directed to serve a notice upon the learned advocate appearing for the respondents and file an affidavit of service on the next day. As prayed for by the learned advocate, for the petitioner list this matter after reopening of the court after Christmas vacation.
But any date, my lord, kindly. At least
after it will appear.
2014 matter, kindly.
It will appear, yes.
Grateful, my lord.
When it was dismissed for default?
2022.
So, now you are in 2024. 2025.
My lord, the transfer brief.
You have prayed that this matter be taken up in 2025.
My lord, it's a transfer brief. So,
when you have accepted
yes,
the benefits
absolutely.
of the brief, you have to also
and the lacuna also
take over the liabilities of
yes.
that also. Yes, next.
Grateful.
129.
127, my lord, with consent of the other side, let it be.
129, one matter is left. Yes.
My lord, I am,
After that, I will come.
my lord, I am appearing one of the petitioner. May I ask for 2 weeks adjournment?
Adjournment. Why, madam? This is the restoration application.
Sir.
You are not ready with the restoration application.
I have not yet served the.
You have not served.
Oh, my.
So why did you mention this matter? The learned advocate appearing for the petitioners, comma, in her usual fairness, comma, submits that no notice was served upon the respondents. First of, let the matter go out of the list. First of, petitioner will be at liberty to mention the matter after serving notice upon the respondents. Yes, next. Password gulo dakun.
I did not
Mr. Chatterjee, you are conceding to that.
asking for the matter to be taken up on 4 orders. That is his request, my lord.
Four
Not for
orders.
the consent.
All right. ওটাকে forwarders দিয়ে দিন।
127.
If it is not reached today. Yes, yes. All right, forwarders tomorrow করে দিন কারণ দেখে আসবে।
I'm good.
Yes, Mr. Acharya. Where is Mr. Nayak? Yes.
Mr. Nayak is for the petitioner, I am for the respondent.
My lord, this is a matter. Not take much time, more than 5 minutes.
15 minutes will take.
15 minutes.
Yes.
He is giving assurance, Mr. Pan. It's up to you.
Please wait and see then. No, please wait and 15 minutes, 5 minutes.
Other matters release. Accepting this.
Remaining matter will call on next day.
Yes. Which item? It will be called on again serially. Yes.
Well, before I start, for the WBSCTCL petitioner, to kindly recall that identical issues have been decided earlier also. But my learned friend said that here is some difference.
What was the identical? Give me a one order. Because I have forgotten everything.
My lord, only thing is, my lord, this is unmetered.
Let me go through the order thereafter. Order টা দিন।
আরেকটা কোথায় ফাইল? বাংলা ফাইলটা কোথায়? অর্ডার করো না, ঠিক আছে, ঠিক আছে।
খুব বাজে।
Yes, so ombudsman in those matters were directed to decide as to the amount of refund.
Refund upon hearing both parties, considering the
Uh,
available records and documents.
Yes. So what is this matter?
Now, my lord, this matter also, my lord, same thing.
Yes, Mr.
They
Acharya,
are
why it is
asking
not
for-
same? What
But
do
he is saying that ombudsman has.
don't want remand?
No. Here ombudsman decided the quantum, my lord, at page 26.
Decided the quantum.
Yes. Mr. Nayak is, my lord, probably has not gone through the brief subject to correction. Otherwise, he could not have been submitted this. My lord, first, second, third, fourth, fifth column, annual tariff. Then actually paid.
Give me, where is that page?
Page 26 of the writ petition.
So excess amount has been quantified.
Quantified. Now it has to be paid.
Mr. Nayak, it has been quantified. in
No.
your order.
Now, my lord, this is quantified how and which manner. That kindly have a look to
Well,
this.
this is
Please,
absolutely
please,
a
accept.
ridiculous
Accept
submission.
it. No. Here on the last, all the orders, my lord was pleased to direct all parties to appear to substantiate their claim and counterclaim, whatever it is.
Because, Mr.
So that
Nayak,
is right.
because
The same
the amount of excess amount was not adjudicated.
adjudicated. Now, here, lordship kindly says,
Here it has been adjudicated.
no
Proceedings.
adjudicated without any basis, without considering any record. Kindly see is this whether that will be accepted by your lordship or not. That's the issue
All right.
to be decided. Kindly come to my lord page.
So according to you, this finding is without any basis.
Without any basis, not only
All right,
basis.
yes, then
Basis one-sided from the
yes, that has to be considered. Yes.
kindly see this page 31. That's the
At page 31.
of the writ petition. That's the order, impugned order.
Page 31. Yes.
Page 31.
এগুলো গেল কোথায়? সব মুছেছে।
Now, my lord, paragraph 7.
কোথায়?
Yes.
Now, my lord, on hearing the submission of both the parties and on scrutiny of available documents on record, it is revealed that the petitioner is continuously processing
He
this
should be
case.
pressing his case to get refund.
No, it is kindly in a few lines only. It is pertinent to mention here that in similar cases of Lanier Arjier who have passed his reasoned order in favor of the petitioner ensuring the refund of the excess amount paid in WBCDCL by the consumer. There cannot be a different decision on similar type of cases through the application, though the application is different, made by a different person. Natural justice demands similar decision for similar type of cases. Hence, the instant case to be rejected on the plea that time barred is not considered, so the application is the applicant is eligible to get the refund of the excess amount from WBCDCL. Now, lordship, next paragraph 8. Based on the factual information, as provided in the case records, the excess amount realized from the complainant for this unmetered service connection during the year 2007-8 to 10-11 as per revealed tariff that of the corresponding years has been calculated, which are as follows. So this is the only modality or mode of calculation and the observation made by as it is recorded. Where is? Then kindly come. We have not given anything, that is the observation. Kindly come to paragraph 19. 19, lordship. In that same judgment.
Yes.
On hearing the submission of both the parties, scrutiny of all documents held on record, it is observed, since the licensee has not produced any letter, official notification, either to the consumer or in particular or in widely circulated newspaper or general information specifying the date of closure of the refund or excess amount realized from the consumer in connection with the temporary unmetered agricultural service connection, the argument with which the licensee wants to nullify the claim as beyond 90 days from the date of occurrence of this cause of action.
So this was on time barred.
No, that is second part. Kindly first two lines. On hearing the submission of both the parties, scrutiny of all documents held on record, it is observed, since the licensee has not produced any letter, official records and everything, and nobody has given.
This is with regard to closure, excess amount, the argument with which the licensee wants to
Therefore,
nullify.
what amount?
So this observation is on the time barred issue. More than 90 days, that is on that.
But if that be so,
Paragraph
if that be
19 is
so,
on that.
if that be so, then kindly consider the which records, from which records, no reference. We have said we have not given anything. And our kindly see our
May
objection.
not have given. Mr. Nayak, page 32.
Yes.
This is the information. The appellant has, the consumer has produced these facts. Have you disputed this?
Yes.
Where is that this, with regard to
Yes.
this number of days?
No, no. My lord, kindly appreciate this. My lord, this is
So if this figure,
this was
Mr. Nayak, kindly take up this chart at page 32.
One second, Lordship. This must be reflected either in the complaint or in the representation before
Yes,
the
yes, in
ombudsman.
the representation.
Ombudsman.
Has to be in the
Kindly
representation.
see the representation.
Where is that representation?
Yes,
Sir?
that is important.
Let
Kindly
me
see
see.
that. Yeah, it is.
Come to that.
We have annexed it. We have annexed it.
Page.
We have annexed it, Lordship.
My lord, page 20.
20.
20.
No, before that, kindly see the original complaint.
Yes,
19. My lord, 19. That's the before the RGRO. Kindly
Yes,
see.
this chart has been given.
No, kindly see 19. Page 19, my lord, RGRO.
19.
Yes. Then, my lord, subsequently, what has happened? That is different issue. Lordship will consider. Ami Sonathan Das Gram Polygram number such and such টাকা জমা দিলে অস্থায়ী কানেকশন দেন কানেকশন বাকি টাকা জমা দিয়েছি ডব্লিউএসসি অর্ডার অনুযায়ী কানেকশন পেতে চাই তাই আমার আবেদন যাহাতে অর্ডার অনুযায়ী এই টাকা ফেরত পাই
সুদ সহ ফেরত পাই. This is the representation.
This is the original representation.
Yes.
Here no milord
But
calculation.
thereafter, page 20, he has given the details.
Yeah, that is before the ombudsman in appeal. Milord, GRO's order, GRO's order is appealable order. He is not happy with the RGRO observation. RGRO held that your claim is barred by 90
Alright.
days.
Before the RGRO,
Yes.
he has made this claim.
Without quantifying anything, without mentioning anything.
No, page 20.
20, that is milord.
Before the RGRO.
This is RGRO.
Yes.
RGRO Sonathan Das
This is the details given by him.
This is again milord another part of it.
Yes.
Another
So if
part
he
of
is given and you have
Now, milord,
the appellate authority, the ombudsman has taken into consideration of this and has arrived at.
and
In
milord,
the earlier matters, Mr. Nayak, it was remanded because there was no quantification.
yes.
Here the ombudsman has quantified this
And
amount.
in that even also kindly consider our objection to that, whether we accept
Yes.
it or
Your
not.
objection
Yes,
to that?
yes, yes.
Let
yes.
him page
Page 23, Lordship.
20.
23.
23, yes.
Number 23, with reference to the above, the following points are submitted before the ombudsman in respect of the petitioner, say Sonathan Das, village such and such and such. And who
You have
is
not said anything with regard to that period.
the petitioner has applied for temporary connection.
Nothing has been
And later
said.
the petitioner had this CC, the refund so and so. The petitioner approached before the RGRO, Paschim Midnapur. So where the draft recent order is concerned, Paschim Midnapur, it is ordered that the complaint of the petitioner related to excess energy bill of the period 2008 to 29 is beyond 90 days. And the date
Only
of
90.
occurrence of this case, therefore, it violates notification 56 of so and so. As no objection was received from the concerned petitioner regarding the draft resident order, the same was declared final resident order by the RGRO. So, my lord, this is the only objection where we have said the RGRO rejected your claim on
But you have not,
limitation.
so here, he has given the
So, my lord-
details breakup. You have not challenged that.
Now, my lord, it was rejected. It was rejected and they preferred appeal before the
Yes,
ombudsman.
appellate authority have
Yes.
considered all these facts.
But we have not, my lord, we have only relied on that 90 days issue. We have not, my lord,
So 90 days issue, the
If it was-
ombudsman has decided, and with this factual issue, the ombudsman has
Now
also
we say-
decided.
now we say this order, this factual aspect without any basis, without any observation, without any reason.
Basis
It is said,
there.
it is said.
Mr. Naik, yes, you have not disputed that before the authority. Or
Well, I say 3 page. Firstly, my lord, the primary, the mother stage, my lord, the RGRO, there this point was not considered at all because 90 days rejected.
yes,
In ombudsman, my lord,
But-
what happened?
yes, there are two things. Before the RGRO, he has given the details breakup. That this is the period during which
It
I have
was dealt
enjoyed,
with. It was not dealt
I have
with.
enjoyed the electricity connection and I have paid these amounts. This RGRO rejected on the ground of that 90 days
Yes, yes.
limitation part. So against that, he's preferred an appeal. Ombudsman has dealt with both the issues. With 90 days, is paragraph 19, that is the finding. And with regard to the factual finding, he has also considered that, and as there is no question of remark.
Will it be sufficient, Lordship? That consideration needs, my lord, supported by evidence. Because this circular says this amount, because the public money after all, circular says this amount to be collected by
You
you.
have not disputed, you have not brought anything before.
Not in the, my lord, the appellate court has decided that. And he
Appellate-
has not.
Mr. Nayak, appellate authority has all the powers of the original authority.
It is a maybe continuous
So
process.
it's a continuation of proceedings.
Process.
Being the last authority on facts, he has the authority to deal with that.
However, Lordship, I say, my lord says so, my humble submission is this quantification has to be supported by evidence. Because that time, what circular, what amount is to be paid? Some person, year to year, he is enjoying. Every year, he is making application for renewal without any protest. He was sitting tight from 8 to 12, he enjoyed. Then in 22, he came to know that some excess amount has been paid. Where law says, my lord, for that regulation was framed, wherein it was stated, made specific that approach within 90 days from the date of cause of action. However, or on sympathy or whatever it is, my lord, that point has been ignored by the Honorable Court and by your Lordship also, and also with the RGRO. And
What point?
the my lord, limitation 90 days.
No, limitation I have dealt with in this order. I have dealt with in this order. Kindly come to limitation part.
Yes.
Limitation part.
Their effect is also different, a bit different also. I'm placing also that. Order taken.
Kindly come to,
my lord. I say, my lord, this has to be verified on record. What exactly? On, my lord, a floating remark, he has made this claim allowed without any evidence.
Paragraph 11, I have dealt with that.
Paragraph 11.
90 days period, I have dealt with specifically in that judgment.
Lordship, I'm sorry in that, Lordship. The argument with the license with
No, paragraph 11.
Yes. Page 6.
Page 4.
Page 4.
Of this judgment, of my judgment.
My lord, that I am.
I have dealt with paragraph 11, page 4.
4. Yes. It appears from the order that RGRO dated such and such the complaint of the objection herein was rejected as it was filed beyond 90 days from the date of the occurrence of the cause of action. Therefore, in violation of 6.1.
That was your argument.
That was my argument, Lordship.
See, I have considered that.
And, my lord, from clause 1A, the notification dated such it is evident that the regulation is to come off. There is 13 prior to 13. It came.
Yes. I have dealt with that point.
That is there. That is there. But 13 came and he, my lord, came to know in 22. Now he is.
This period is for which period? Claim is for which period?
8 to 12.
So
8 to 12.
So it's start to take the 30.
Lord,
So I have dealt with that. Don't say I have avoided to deal with that.
He cannot.
I have dealt with the period of limitation.
He cannot.
Because on that occasion we have argued, so I have considered that. I have also not only relied upon the order of the Ombudsman with regard to the Ombudsman. I have dealt with that.
But I also
so here also
says,
8 to 12.
Very well, my lord, we have not objected to. Even if we have do not object to, an officer is not objecting, public money dealt with by WBCDCL to be given
Nayak,
on my consent.
What will the appellate authority do? Let us
said calculation is there approved.
Yes,
Lord, I am
let us
putting
assume
only one question.
a
Is
claim
it
has
the
been
public
made.
money or my money?
Let us assume.
Yeah, they have taken.
Let us assume a claim has been made by the claimant. So you do not oppose that before the appellate authority. You do not challenge that. So appellate authority will take it that has not challenged.
My lord, on this issue, my lord,
appellate authority we have not challenged.
My lord is much more, my lord, vastly wise on this issue. Any observation without any evidence, a quantification is coming. Since I am not opposing or not opposing may be different factors. One, my lord, station manager is coming to deal with here 76,000 in this matter, other matters 70,000 in this way. There are, my lord, crores of rupees. There was a racket. Now one officer dealt with all these cases. If he says yes, then, my lord, he will get it. It has to be supported, fortified with the evidence, my lord, what I say.
Yes, but for the purpose of setting aside, I have to hold that why it is suffering from infirmity. There is
That is that.
nothing.
But
because
I say,
materials, on the basis of the materials and remand, Mr. Nayak, is not a matter of course. Remand, if you can show here that you have disputed, what is the dispute? Show me from your records. that you are disputing this. Nothing has been produced by you here.
Which is advancing now.
Have you disputed, have you made any statement with regard to
Lord,
that
my lord,
calculation in the
for
writ petition?
for the infirmity on the part of either the officer or my lord, the lawyer, if at all,
Is
then
there
my
any
lord,
submission
no,
regarding
my
the
lord
I accept that.
says-
But what have you said in this writ petition?
Yes.
Have
One
you
second.
challenged that before this court also?
No, my lord, only my lord, page 32.
All
if
right,
omit-
tomorrow for orders, Mr. Nayak.
tomorrow forwarders. What about it?
All the matters are same.
Same.
In all quantified.
Same issue, same issue.
All right.
Almost. My lord, may I file or my lord, reply in all these matters?
File tomorrow. I'm keeping it.
Lordship.
Uh,
Only
all
my,
right,
my,
ওটা করে নিন।
my sole contention, my lord,
You are filing
considered
what? Reply.
reply to affidavit in opposition.
Affidavit in opposition and the reply. এটা পুরো বাঞ্চে আছে, হ্যাঁ? Affidavit in opposition and the reply filed in court today are taken on
In
record.
all the matters, lordship, we filing. Five
Mr.
matters. Five matters.
Mr. Nayak, learned advocate, appears for the petitioner. Full stop. Mr. Nayak commences his argument but could not conclude due to paucity of time. This matter tomorrow under the heading for us. একদম উপরে দিয়ে দেবেন এটা।
Tomorrow, my lord, would be pleased to have chance, my lord, to take up the matter tomorrow.
Why?
My lord is sitting tomorrow. Singly.
Any difficulty?
No. I have no. Only my fortunate, whether fortunately we shall be getting my lord's presence or not. Because if division bench comes in, then again, my lord.
That is always there.
So in that way, make the program. That's what I'm saying.
Let us
Otherwise,
see.
my lord, to appear before my lord is always pleasure to everybody, not that of mine.
Yes.
Lordship. A same order it is.